call the meeting to order. And our called meeting is to discuss the qualification requirements for members of the Board of Education, for the candidates that are going in. We have in your folder, you have a letter from Superintendent Curtis Jones. I assume you all have looked that over. The question is whether Mr. Kendall, who has qualified to run for election again for school board, whether he fulfilled one of the requirements, which is to complete a minimum number of board member training hours each year. Dr. Jones says he has not. So on the second page, and I've not seen this before, so let me just look at this. On the second page, it has the number of hours earned. Everyone else had 9, he had 3. Everything else was the same. All right, looking at the next page. Oh, I see. These are the actual days. Is that your understanding? These are the actual days that they're coming. That's my understanding. Are we to determine whether his candidacy is, his candidacy is good or not?
The answer to that is yes and no. Let me just read you the applicable code section, okay?
Okay.
And that is 21-2-6 in the official code of Georgia, subparagraph B, which states that the superintendent, upon his or her own motion, may challenge the qualifications of any candidate. Now, it goes on to talk about any elector can do the same, but the superintendent can do so on their own motion. And if the question arises, then upon the superintendent, either upon his or her own motion or upon the challenge being filed, the superintendent shall notify the candidate in writing that his or her qualifications are being challenged and the reasons therefore, and shall advise the candidate that he or she, that's the chairperson, superintendent, excuse me, is setting a hearing on the matter and shall inform the candidate of the date, time, and place of the hearing. Now, at that hearing, that is sort of an evidentiary hearing where you're there to receive evidence. If there's a challenge, what are the grounds for your challenge? Why do you contend this candidate is not qualified for whatever reason? Obviously, the candidate would have a right to rebut the evidence, cross-examine them, offer his own evidence. It'd be like a mini trial of sorts. In the event that the superintendent determines that the person is qualified, then that's pretty much the end of it, and everything continues to march. If you, at the conclusion of that hearing, conclude that he is not qualified, and you state the reasons why, in your belief, he is not qualified, then that candidate would have the right to appeal that decision to the Superior Court, contending that your decision is wrong. And I'm pretty sure that would be a de novo hearing. Yes, it says the review shall be conducted by the court without a jury and shall be confined to the record. The court shall not substitute its judgment for that of the superintendent as to the weight of the evidence on questions of law. The court may affirm the decision or remand the case for further proceedings. The court may reverse or modify the decision if substantial rights of the appellant, that would be the candidate, have been prejudiced because of findings, inferences, conclusions, or decisions of the superintendent or violates the Constitution of the law, in excess of statutory authority, made upon unlawful procedures, affected by other errors of law, etc., clearly erroneous, some of the typical grounds where an appeal results in a reversal. So, like it says, the court doesn't substitute its judgment as to the weight that you give to certain evidence on questions of fact. In other words, they're not going to say, well, I wouldn't have given it that much weight, so I think you're wrong. So it's not a de novo hearing per se. As it states, it is confined to record on appeal, so to speak.
So since we have been served with it, or not served, but notified of a challenge, we must go ahead.
And we need to go ahead and set a hearing date.
Hearing date, okay.
Which we need to do within reason as soon as possible. Obviously, Mr. Kendall needs to have adequate time to prepare. And I don't know whether Mr. Kendall is going to represent himself or whether he will have other counsel. I don't know. But yes, we will need.
Or what would be adequate time?
Mr. Kendall?
Adequate time to do what?
To prepare for, like,
To prepare
so we
for
could set a hearing date.
Well, to be quite honest, Ms. Grayson, I can't actually see any need for a hearing. I think you
Well, I
got a whole
think we
bunch of.
legally have to.
No, I don't think you legally have to do anything. I think if you intend to make a challenge to my qualification, if that is, you making a challenge to my qualification, I think it would be incumbent upon you as a chairperson to find out for yourself whether or not there's any grounds for a challenge. Not just to take the superintendent's word for it. Now, if he wants to make a challenge, then he needs to file a challenge. But if you intend to file a challenge.
Well, there's a problem there because he cannot file a challenge as a citizen.
Yes, he can.
No,
He's
because he's
elected.
not in your district.
Okay, well, if he's not in my district.
So,
Well, hang on just a bit. I think, and I realize that, and this is getting into the meat of the matter on the faction, et cetera. And all we've got here is just prima facie statements. I think that we could, that the superintendent may, upon his or her own motion, may challenge the qualifications of any candidate. So I think in this case, then the superintendent can certainly challenge the qualifications of the candidate. We need to do so in writing and tell Mr. Kendall why we're challenging it and what reasons we have for believing that he may not be qualified, and that we need to have an evidentiary hearing to get to the bottom of it.
right.
I mean, that's what I think we need to do. And Mike, assuming that that's what's going to happen, what would be a convenient time, or how much time do you think would be reasonable to give you to prepare?
Well, I think if after you do your due diligence and you find that there is some grounds to challenge my qualification, then I think maybe 15 days is enough. You tell me what it is you're challenging and everything, and then.
I think once, this is my understanding, once we have been aware that there is a conflict, it would be like when somebody is not living where they say they are, and someone comes in and gives us that information. We now have that information. I mean, this was sent to us, this is our information. I agree, we need to look into it, but I think that's what we would do at the hearing. I don't think I can right now say,
Well, how can you
we
file?
don't need a hearing.
Well, how can you file a challenge if you don't, if you have no?
This is our challenge.
Well-
We have been given this, and we have to go forth with it. Whether we agree with him or not, doesn't matter. I mean, we have to look into it, and I think that's what we'll do at the hearing.
But don't we have the option of not challenging?
I don't think we do, once we have something in writing. I don't think we have an option.
I don't believe that. I mean,
Well,
we can say we don't challenge his qualification, can't we?
but then what happens with this?
Well, he can file a challenge, or he can go
No,
find
he
somebody else
can't.
to file a challenge. If somebody out there, some person that's got legal standing to challenge my qualification, wants to challenge it, then that person can certainly go challenge it. Or the board, if you got some reasonable ground, and if you think a letter from him is your reasonable ground, without you looking into it, and you think just because he sent a letter down here, that's reasonable grounds to file a
No, I
challenge.
think that is grounds for us to look into it.
Right, and then once you look into it, and you figure out whether or not there's any substance to what he's saying, and then the board votes to challenge my qualifications, then I think you set up a hearing. But just based on him sending a letter down here, and as you just said, I guess you're correct, that he doesn't have any standing to file a challenge to my qualification, if you're right. So by him just sending a letter down here, a person that doesn't have any standing to challenge it, how does that give the board some notice that my qualifications need to be challenged? You haven't determined that. I take it this board hasn't investigated any of this to determine whether or not there's a need for a challenge.
We have just gotten this, and
But
that's,
he said the superintendent can challenge it. Didn't you just read that, sir?
Yes, the code sections
right.
state
No matter where
that
you-
the superintendent, upon his or
We,
own motion, may
We are
challenge
just-
the qualification.
Right, the election superintendent, not the superintendent of the
not the
school.
superintendent.
Well, no, so I'm talking about the election superintendent.
right.
If that was if I confused anybody, we're talking about the
Yeah,
election
that's what he was
superintendent.
confused.
That's us.
Uh,
It seems to me, Madam Chairperson, that once you get this letter, somebody says something to you, makes an allegation, then it's incumbent upon the board to do its due diligence
Oh,
to
I agree.
verify whether or not there's any reason to follow up on this, and then you vote to ask whether or not you want to challenge my qualifications. And then, once you do that,
I don't think that's quite the procedure. I
Okay.
think that once they're put on notice that there may be grounds to challenge it, I think that's adequate for them to call a hearing and say, look, this allegation's been made, we need to have a hearing to hear both sides of this thing.
well, who's going to come on the other side? Is the superintendent of the schools going to be subpoenaed down here to substantiate his letter?
Well, I don't know if we're gonna have to subpoena him or not, but I mean, obviously, it was their documentation that said you hadn't fulfilled the educational requirements.
Well, but how does he have standing if you just said he can't challenge my qualifications? How is he going to be
He's
called?
just making us aware,
He's
it's
gonna
fine.
be- He is gonna be a witness as to the facts of the matter, and she's issuing, the superintendent issues the challenge.
Well, I think you got a threshold question though, Mr. Fortune, as to whether or not the statute actually says that I didn't comply with something. See, I think somebody needs to read the statute.
Well, I'm looking at it.
No, I mean the statute about what constitutes qualification. Because the statute only says that the candidate must agree to disclose whether or not you complied with the training. That's what the statute says.
I thought it said that you had to disclose compliance, i.e.
said
that
right.
you had complied with it.
Yeah.
But that's what we would need to take up at a hearing.
The legal issue, the question of what the statute says?
No, I know what, well, the statute, I mean, I think what you're, hang on.
what you signed? Is that what you're
This is
talking
Georgia Code, OCJ 20-2-51. And this is a
Right, but this is
subparagraph E2, which states that the candidate has agreed to annually disclose compliance with the State Board of Education policy for training, blah, blah, blah. So it doesn't just say disclose, you're supposed to disclose whether or not you've complied,
Thank you. Whether or not you comply.
right?
All you gotta do is disclose whether or not you did or not. So if you didn't comply, you just have to disclose that fact.
Well, okay, well, I believe your local board, though, has adopted the rules and regulations that say you're supposed to have X amount of training,
Right. So if you didn't do the training, you have to disclose that fact.
okay?
That's all you have to do,
You're
is
saying
disclose whether or not you did it or not.
And your position is that you don't have to comply with the education requirements
As long as
as
you
long as
disclose.
you simply say, I only got 3 hours instead of 9, which you
That's what-
did.
That's what the statute says. It says you agree to annually disclose whether or not you comply with the training requirements. So if you didn't comply and you disclose it, you have complied with the statute.
All right, but now the school, our local board says, and I guess this goes back to the state, that you must participate in all required training programs developed for board members by the board or the State Board of Education.
Okay. And you have to disclose whether or not you did that.
Well, you have to participate,
Okay.
but if you don't participate, how can you say you did?
Well, what do you mean participate? What does that mean?
Go.
I would
Go-
say
I
go
Go
went.
to
to the classes.
I went to the classes.
Where was that language that you just read?
This is what I got from the basic principles and procedures of Spalding County School.
Spalding
You want to
County, the school system?
Pass that down.
Subsection E of that code states that used to provide a member of the local school board with a completion of a minimum number of hours. What are those, what is the minimum number?
9.
9?
9? He
Well, I
told
mean,
me it was
that's-
15.
I beg your pardon?
I said, he told me it was 15.
No, I think it's 9.
It's 9.
I just said 9. I agree with you.
Oh, well, I'm
I don't know who
saying-
said 15.
The
It's 9.
superintendent told me, not Ms. Grayson, but Curtis Jones told me it was 15. Now, I'm not sure.
We've
which
got
one.
it right, and it says 9.
It says 9.
Do we have a copy of 22.5 subsection E?
Yes,
That
you do.
Dr. Jones is,
Yeah.
the sheets are 22.1.
It's 22,251. That's a mistake on the letter.
Yeah.
It's 51, not 5.
There we go. Okay, so that's 51. Okay, so that's
51.
wrong. E, so that's referring to that, right? Okay.
Hell, let me throw something else in here.
Okay.
You know, this is a promise that he will do. That's what he signed. It has nothing to do with the last 4 years, the way I see it. He's just saying, I will. Come what
Exactly.
may.
But he signed that
I don't care
also
what he did.
at the beginning. Right, you're right. Oh, I see what you're saying.
You know,
Well, what about a
I went
person?
all through this thing, 22, whatever it is. There's no penalty for not doing it right, that I can find.
Well, if you look at
He's
20 days,
promising that he'll do it next time.
Well, what about a person
Whether
who's
he
never
does or
been
not is
an
a
elected
different story.
official? What did that person, what's the requirements, if you've never been a school board member, and you come down here to qualify, what's your training requirements if you've never been a school board member? Can you qualify, you haven't gone to any classes?
I can't answer that. I don't know.
So, I mean, if I had never been on the school board, and I came down here to qualify, do I have to
Right.
take some classes?
Well, you do.
Or he could resign, and it wouldn't have the problem. Is that what we're saying?
So there are different requirements for people who have already served and people who have never served.
Mike, can I ask you a question,
Yes,
son?
ma'am.
When you qualified before to be on the school board,
Yes,
and you,
ma'am.
and you knew what the requirements were for your continuing education, why didn't you go?
No. See, you assuming that I didn't go.
Well, you just
See,
said you didn't.
No, I didn't. No, I didn't say that. You assuming that what he sent you is correct.
I understood you to say you didn't go.
No, I didn't say that.
This did not come into effect until after you were already in office. So
Right,
you didn't have to fill this out when you qualified.
exactly. I didn't even have to do that. And you assuming that what he's saying is correct, and I'm telling you it's not. So you just assuming that what he's saying in that letter is accurate.
No, I thought you said you didn't do it.
No, I didn't. I didn't say that in
Whether
the
you
least.
did or not, I wasn't there. I didn't go myself. so.
No, I did not say that. I went to all of these things. I did not say that at all.
Well,
So you gotta assume that his numbers are right in the first place.
well, Mike, let me ask you this. During the fiscal year that we're talking about, where your disclosure states you had 3 hours. I mean,
Well-
that's what you signed.
Okay, now, see, what he has given you, and this is what I understand about how this works. See, he called me a couple of months ago and told me that I had not complied with the number of hours the first year I was on the board.
Okay.
That's what the information this Curtis Jones told me.
Okay.
So I called up to Atlanta to find out how this stuff works and who had the records. I called the School Board Association. They told me that you only had to have 15, but I had 16. And then they said the people at the State Board of Education, they have classes that people go to, and the School Board Association has classes that people go to. And the two don't combine their records. So the lady at the School Board Association said, according to our records, you have 16 hours during the first year you on here. And I don't know what they have at the School Board Association. If you took some classes from the School Board Association, the Department of Education conducted, they may have a whole different set of records over there for you, and you may have taken some hours over there, so you may have more than 16 far as we know. So I called Tim Shepard back and told Tim that, look, the superintendent said I needed 15, the lady at the School Board Association said I got 16. So this should be the end of that whole story. I heard nothing else about it. Nobody said anything to me about it. I thought it was a dead issue because the lady told me I had 16 when he said I needed 15. Case closed. I'm through with it. I don't hear anything else about this until yesterday when Zach Holmes calls me and says, you need to hurry on down to this elections office because the superintendent has sent a letter down there saying that you haven't taken all of your hours at some point in time. I didn't know until yesterday that now he's trying to say I didn't take the hours in another year. I never heard that until yesterday, and I saw this stuff when I got here. They never sent me a copy of the letter. He never said anything to me about it. I never heard anything from Tim. I heard it from Zach Holmes yesterday. So I haven't even had a chance to go check on none of this stuff that he's got in these allegations in this letter because I never heard it until yesterday. Okay. So for you to go saying, well, I'm taking his word for it,
Well,
and I'm going to have a hearing based on something the superintendent said, and he doesn't even have any standing, nor is he the official record keeper, to my knowledge. Y'all really jumping the gun talking about having a hearing before somebody goes and figure out what in the Sam Hill this statute says, and whether or not the superintendent's records are even right, and whether or not this year that he's talking about that I didn't take but 3 hours, because he's telling me I needed 15. So I have had a chance to verify none of this stuff he's talking about because I just got it.
Isn't that a real good reason to have an evidentiary hearing?
No, to me it's a real good issue for the superintendent, the school board, and their attorney to determine, number one, whether or not the school board has got any standing to be sending that letter. That's the first issue for me, because I don't think that the school board has any standing
Well, I
to
don't
be
think
trying
we
to.
need to be.
that's not
That isn't part of
that's
our-
not our
Okay,
problem.
that's not your problem.
No.
Okay, now
Our
your
problem is that we have become aware that he is not happy with whatever hours you have put in, obviously.
okay. So if he's not
So if
happy,
he's not happy with it, we need to find out what his criteria is, why
Why is
you
it-
have
why-
16 and he has 3.
Let me,
But I'm
let
saying,
me
well, why
just,
is it that the superintendent gets to make, he doesn't make any rules?
Mr. Kendall, hang on just a second. When we got to print it out?
I have to have them in hand and tested by April 4th.
April 4th. Today is the 7th, right? Let me make a suggestion. What Mr. Kendall says about the statute is certainly not a model of clarity. It's true. And I don't think that we should be sitting in judgment on the school board's law and whether or not he has met the compliance or not. And I think that what we could do is we could set a hearing out there 10 days from now or so, go to the school board, go back to their attorney and say, these issues have been raised and we need you to give us your opinion on the matter and whether or not there is even a requirement that he take it. And depending on what their answer is, we've already got a hearing set. We could go forward with an evidentiary hearing if we felt the necessity, or they came back and said, you know, he's probably right about this stuff. If there are no requirements, there's nothing for us to hear at that point. And we could dismiss the challenge. But that would save us from having to have another meeting to set a hearing after we get a ruling from the school board attorney and the school board.
Okay,
Now,
how do you
that's,
feel about that?
I mean, Mr. Kendall, what do you say about that?
That makes eminent good sense to me. However, I would point out to you, I got an email from Mr. Westbury today saying that this is not a school board matter.
Well,
I made that same suggestion to him via email last night when I got all of this
Well, I
and
don't
asked,
think he has to, anything to say. I
well,
think
the
this
school
is up
board
to us,
obviously
whether-
would need to speak, he's an individual member, but he's not speaking for the board.
Right.
right, I suggested to him that the school board needs to have a meeting to clarify this. His response to me was that this is not a school board matter and the school board doesn't have anything to do with this. So my response to him, well, if the school board doesn't have anything to do with it, why is the superintendent sending a letter down there to the Board of Elections on the school system letterhead signed by the superintendent in his capacity as the superintendent, if the board didn't have anything to do with it?
Well, we might disagree with them on whether or not it's a school board matter or not, but my recommendation is we look out 10, 14 days from now and set a hearing so that that part is a done deal and everybody knows when that hearing is.
Well, just so you'll know, I have a Wednesday deadline. He will be on the ballot if we have not held a hearing by then.
This coming Wednesday?
Yes. It takes a while for these things to be printed and processed.
Oh.
So I can put him on the ballot because he has not been disqualified.
Correct.
Right.
So I will put him on the ballot.
And if we had to, we can strike it later.
Right. Just so everybody knows that.
All right, okay. Well, Mr. Kendall, looks like you're gonna be on the ballot, buddy, one way or the other, but, so, is that satisfactory that we proceed in that manner?
Yes, I think so.
Anybody got any questions?
So can you repeat that for me just one more time?
Sure. I would suggest that we go ahead and, assume that the challenge has been made and that we need to have an evidentiary hearing, just like the code section requires. And to go ahead and set a date, so we've got that accomplished and we know when we're gonna have a hearing. In the interim, though, ask for an opinion by the school board attorney and whatever opinion the school board might have as to, are you required to even have any educational credits? I mean, are you in violation of the statute? I don't know anything about your 16 hours versus 3 hours. I don't know anything about that, but ask them to look into that and come back and tell us, well, yeah, it looks like he's got the number of hours, or no, he doesn't because of this, that, or the other. And depending upon their answer to us, we can either, if we say, well, there's no issue for us to determine, we cancel it, dismiss the challenge, or if we decide we need an evidentiary hearing, we got it set and we proceed.
Well, let me say, I only think you get to the issue of the number of hours once you determine whether or not there is in fact a requirement that you had the number of hours in the first place.
That's exactly correct. But
That's
let's
what
just
we need to
assume,
determine, but we can't determine it
We don't
without a
know.
little time.
Beg pardon?
We need some time too, and I think we've got to,
That's what I said.
but you know, but Mike, whether there is or there isn't, if they come back and they say, well, we didn't know about those 16 hours, so he's really got 19 and he only needed 9,
No,
it's not an issue any longer. I don't know.
okay.
I
See,
don't
I think
know.
at some point you're gonna, I guess if you might get to it, my opinion, you're gonna never get to it, but there's a threshold question as to whether or not, in order to qualify to run, a person in my capacity who has served on the school board, is it a requirement for me to qualify for this next term that I had to go to some classes during the last term? See, that's the issue, because basically what it sets up is two categories of people. A person like myself who is an incumbent, who is required to have taken classes in the past, whereas you got a person who has never been on the school board, has no requirement to have taken any classes and can come down here and qualify. And I think that is really the issue that you have to decide.
I would argue that there's actually, based off of that logic, and there would actually be 3 classes, because a new board member would have to take 15 versus a veteran board member taking 9.
Right, they
Following
got,
that train of logic, and there's actually already classes of school board members based off of whether you're a new board member or a veteran.
right, and that's the question. Does the statute require a person like myself to have taken these hours in order to qualify to serve under that statute, when the statute merely says is that you agree to disclose in the future whether or not you comply? It doesn't say anything about what you did in the past. You have to sign that statement saying, I agree to disclose compliance with the training requirements. It doesn't say anything about what I did in the past. So you're going back trying to say what I did in the past has an impact and disqualifies me from qualifying for the future. I don't read that statute like that at all. And how the superintendent comes up, and that's the way he reads the statute, that
did you qualify last time?
when in 2010,
And that's when that went into effect.
I think it
Sometime
was,
after that,
I think it began sometime in 2011.
right, I think it began in 2011.
2010, I think.
So when I qualified the first time, I don't think that statute was actually on the books.
Not intent.
So I didn't have to sign that statement. I didn't have to do any of that. You know, I wasn't, when I ran for office, I didn't have to agree to do any of that. So now you're telling me I was on the board, I didn't have to do it in the first place. And now when I get down here to qualify this time, now you're trying to tell me I had to go back and I had to qualify, whereas somebody who had never been on the board.
We're not in the hearing right now.
Well,
I'm saying, we need to have some time to do this. And we're not gonna argue about it anymore right now.
well,
We need to set a date.
But Ms. Grayson, let me say this. If you're telling me you get ready to set a date for a hearing, that means I need to start preparing for this hearing. So it makes a lot of difference to me.
And so do we.
Big pardon?
And so do we.
Right, but I'm saying, are you saying that you're challenging my
I'm
qualifications?
saying that we're going to set a hearing. We're going to study it now. If we find out that we don't need to have a hearing, we won't have it. But we can't very well just say, okay, we're gonna take your word for it when we have somebody
But I know,
else's
But
word.
can you set up a hearing without officially challenging my qualifications?
I believe we
Well,
can
we need to send you a letter,
say,
but for the sake of getting things accomplished in timely fashion, we'll send you a letter that says, they say you're not qualified, we need to look into the matter, we're gonna have an evidentiary
But
hearing.
Mr. Farley, let me respectfully disagree with you.
Okay.
That I don't think this board can say, somebody else said that they are challenging your
How
qualifications.
else
I think
would
this
they,
board
how
has to.
else would they
how
get,
else would we know
how
about
else
it?
would they ever find out?
I'm not saying you, however you found out, through whatever means you found out about the problem, this board, or, as you said, an elector, isn't that the term you use in the statute?
Yep. Elect
And an elector would be somebody who lives in my district, right?
somebody who could vote for you, or
Somebody who could vote for me. Either that person or this board has to officially file a challenge to my qualification.
I think we're all in agreement there.
Okay,
we
so
don't disagree.
the question is, how, if there's no elector out there who has done this, and Curtis Jones can't do it because he doesn't live in my district, who is it that's challenging my qualification?
It would be this board would
Elect.
challenge it on the information that we have received.
Okay,
It would be similar to, somebody came in here and said, I want to complain about Mike Kendall qualifying for District 3, or whatever your district is, because he doesn't live there, he lives over in District 2, and he can't run for that board. Well, we couldn't just say, oh, well, we don't have actual knowledge of that. So that would be, I think, sufficient to at least challenge it for the purpose of having an evidentiary hearing to gather the facts.
okay. But can, you tell me, I don't know, can the chairperson of this board, the way you read it, that person by themselves can file a challenge, or does it take a majority vote of the board to file a challenge?
Does not say that.
That's what I'm saying. It does, it sounds like the one person, the chairperson, by him or herself, can actually file a challenge.
Generally, the whole board is considered the superintendent.
I would imagine that if the majority of the board said, we don't have any business filing a challenge, I don't think the superintendent is gonna say, well, the heck with you people.
Right.
I'm gonna charge off on my own and do it. So, I mean, perhaps they need to have a vote of whether to
Right, I
proceed with
agree.
the challenge or not, and if the answer is proceed, then we will send you a letter, so forth and so on. And
I
we'll-
think that's the proper procedure.
that's fine, and I think that's certainly reasonable. And if the board decides that there's sufficient evidence that they need to at least challenge it and look into it, then I propose we go ahead and set a date so everybody knows when it's gonna be. I will be back in touch with the school board folks, telling them where we are and that we need their assistance and we need them to make some decisions and do it in writing, so that we know what they say. They come back and say, you know, we're all wrong, he's not, we can all go home. We don't need to have a hearing. Is that reasonable?
I think that's perfectly reasonable.
Thank you. Well, Madam Chairperson, in that case, then I think it would be, the thing to do now would be to ask the board to vote whether or not they want to proceed with challenging its qualifications or not. And based upon the outcome of that vote, take appropriate action.
All right, I have to have a motion.
The motion would be, if you're in favor of issuing a challenge to Mr. Kendall's qualifications, raise your hand. Let's see if you get 3 votes.
Okay, if you are in favor of issuing a challenge, would you raise your hand?
3. I'm assuming the other 2 gentlemen would vote no. Okay, we've got 3-2 to proceed with the challenge. Okay.
All right.
We will send you a letter, Mr. Kendall.
Okay.
Now, let's try and set a date if we can, so that we have got that little housekeeping chore out of the way.
A week from today,
I would push it a little,
further?
once we don't accomplish it by Wednesday, Mr. Kendall's gonna be on the ballot.
Right.
So we can't get it done between now and Wednesday. I would propose a minimum of 10 days from this point to give the school board time to do their work and their attorney to render an opinion for us. Because whether or not we need a hearing is going to depend a lot upon what they come back with. So, what is today? 7th? Next Friday's 14. What's the next Tuesday or Wednesday, somebody?
Tuesday's the 18th,
And then 19th is Wednesday.
Wednesday.
Mr. Kendall, you got any preference there?
I will be gone from Wednesday to Friday.
Okay, so Tuesday's our day. 18 March? I know.
I don't know if I don't have my calendar in front of me, I'm not one to walk around with it on my telephone.
I don't know.
March 18, you say?
Yeah, 18 March.
That's to do what?
That would be our evidentiary hearing to look into
If
the grounds for
necessary.
the challenge.
Okay, so at what point in time am I going to officially get the grounds for this challenge?
We will bring you a letter on Monday. Would that be okay? I think you pretty much understand what the deal is. I mean,
I just need to know what I need to be prepared for.
I understand. So why don't we say March 18 at 9 a.m. here? Is
Okay?
that okay with everybody?
Yes, sir.
What?
9 a.m.
18th
And
at
that's
9.
a Tuesday.
That's a Tuesday.
I guess. I don't have a calendar either. Okay.
Meeting, we have a meeting though, that,
Right, then,
Yes, we would.
this will be the next week.
this will be the next week,
Okay.
the week after that. Yeah. All right, any other business? Meeting is adjourned. Thank y'all for coming.
Thank you, Mr. Ford.
Thank you, Mike. See you, bud.
Okay, see y'all later.
See you, man.